Hello Year 12s and welcome to this video on the division of lawmaking powers between the Commonwealth Parliament and the state parliaments. In this video we'll be looking in detail at some parts of the Australian Constitution.
The Constitution is the single most important piece of legislation that relates to Australia. This is because it establishes and sets out the roles of the Commonwealth Parliament and the High Court of Australia. It also provides that all executive power at the Commonwealth or federal level is held by the Governor-General as the representative of the Crown or the Queen. In fact, the Constitution is actually part of a British Act of Parliament. It's not part of an Australian Act. And the reason for this is that before Federation on the 1st of January 1901, Australia simply consisted of 6 separate colonies that belonged to the United Kingdom. There was no Commonwealth Parliament in existence that could pass the Constitution. Indeed, it is the Constitution that creates the Commonwealth Parliament. So, at Federation on the 1st of January 1901, the Constitution came into operation, the 6 colonies became the 6 states with their separate parliaments that we have today, and the Commonwealth Parliament was established. One of the most important things that the Commonwealth Constitution does
is to provide for the division of lawmaking powers between the Commonwealth Parliament and the state parliaments. There are 4 kinds of powers that we are looking at, and it's important that you know the definition of each of these kinds of powers and that you can give at least one example of each of these kinds of powers.
The first kind of power are the specific powers, and these are the lawmaking powers, LMPs. Don't use that abbreviation in the SAC or exam, that's what I've used for the purposes of these slides only. LMP stands for lawmaking powers, and specific powers are lawmaking powers expressly given to the Commonwealth Parliament by the Constitution. The only lawmaking powers that the Commonwealth Parliament has are those lawmaking powers which are given to it by the Constitution. And the main section of the Constitution that gives lawmaking powers to the Commonwealth Parliament is Section 51. So let's turn to Section 51. You can see that Section 51 starts off by saying that the Parliament, and references to the Parliament in the Constitution are references to the Commonwealth Parliament. It states that the Parliament shall, subject to this Constitution, have the power to make laws for the peace, order and good government of the Commonwealth, that is Australia, with respect to, and then it lists a whole lot of different matters about which the Commonwealth Parliament can make laws. So, for example, it can make laws about trade and commerce, that is in subparagraph 1, Roman 1, which looks like a little I. It can make laws about tax, that's in Roman 2. It can make laws about marriage, that's in Roman 21. It can make laws about external affairs, that is Australia's relationship with other countries. That's in subsection 29, XXIX. There are actually 40 matters about which the Commonwealth Parliament can make laws. There are 40 subparagraphs in Section 51. Now, if you go to the end of Section 51, it actually looks like there are only 39 matters because the last paragraph is XXXIX, which is 39 in Roman numerals. However, the reason we say that Section 51 contains 40 heads of power, or 40 matters about which the Commonwealth Parliament can make laws, is because in 1946 there was a new head of power added, which is XXIII capital A, that is subsection 23 capital A. So that's why we actually have 40 heads of power. So the important thing here, though, is that specific powers are those lawmaking powers that are expressly given to the Commonwealth Parliament by the Constitution, and that's important because the only lawmaking powers that the Commonwealth has are those which are conferred on it by the Constitution. The second type of powers we have are residual powers. Now, residual powers are those lawmaking powers that the Constitution does not give to the Commonwealth Parliament. In other words, these are lawmaking powers that the state parliaments retain, because remember, the principle is that if the Constitution doesn't give a law-making power to the Commonwealth Parliament, then the Commonwealth Parliament doesn't have that law-making power. However, the state parliaments, which have been around firstly as colonial parliaments before 1901, and then after Federation as state parliaments, they had the power to make all sorts of laws with respect to the colonies and then the states. And some of those powers have been retained by those state parliaments. Think about what the state parliaments are responsible for. They make laws about education, so our schools, public transport, the trams, the buses, the trains, and roads. And the reason that these are matters that fall within the residual powers is that the Commonwealth Constitution does not give the power to make laws about education, public transport, roads, and so on to the Commonwealth Parliament. That is, these are powers that are left with the state parliaments. Now, the important thing about the residual powers is that the Commonwealth Parliament does not have the power to make laws about any matters that are covered by the residual powers. As I've said, those matters include things like education, public transport, and roads. Coming back to the specific powers, there are two types of specific powers. The first type is the exclusive powers. And exclusive powers refer to law-making powers that can only be exercised by the Commonwealth Parliament. That is, the state parliaments cannot exercise these law-making powers. The other type of specific power that we'll come to shortly is concurrent powers. But before we do that, let's look at the three types of exclusive powers. The first way in which a power can be exclusive, that is, the power to make laws can only be exercised by the Commonwealth Parliament, is where that power is one that the Constitution states is exclusive to the Commonwealth Parliament. That is, the Constitution actually says only the Commonwealth Parliament can exercise this law-making power. The best example of this is Section 52. If you turn to Section 52, you'll see that it says that the Parliament shall have the exclusive power. That means only the Commonwealth Parliament can exercise this power to make laws with respect to, in the first subparagraph, Roman 1, the seat of government of the Commonwealth. That refers to Parliament and the fact that it's located in the Australian Capital Territory. And 2, matters relating to the Commonwealth Public Service. So under Section 52, an example of exclusive powers that are exclusive because the Constitution says that only the Commonwealth Parliament can exercise them is the power to make laws about the seat of government and the power to make laws about the Commonwealth Public Service. Another example of these kinds of powers is found in sections 111 and 122. Section 111 is a part of the Constitution which allows the Parliament of a state to surrender any part of that state to the Commonwealth. And this has happened before. The Northern Territory used to be part of South Australia, but South Australia surrendered the Northern Territory to the Commonwealth so that it became the responsibility of the Commonwealth Parliament. And similarly, New South Wales surrendered what we now know as the Australian Capital Territory. It surrendered it to the Commonwealth so that the Commonwealth now became responsible for the Australian Capital Territory. Section 122 states that it is for the Commonwealth Parliament to make laws about the territories. So it's actually the Commonwealth Parliament that has the power to make laws about the governance of the Northern Territory and the Australian Capital Territory. And again, you can see from reading section 122 that it refers to the Commonwealth Parliament having this power, not the state parliament. So again, only the Commonwealth Parliament is able to make laws about the territories, and that demonstrates that this is an example of a law-making power that the Constitution says or states is exclusive to the Commonwealth Parliament. The second way in which a power can be exclusive to the Commonwealth Parliament is where it is exclusive by nature. What this means is that when you read the power, you know from the nature of the power that only the Commonwealth Parliament can possibly be intended to make laws about this particular subject matter. So let's have a look at some examples. Turn to section 51, subsection 4, that's IV in Roman numerals, and you can see that this confers on the Commonwealth Parliament the power to make laws about, and reading from subsection 4, borrowing money on the public credit of the Commonwealth. In other words, this is a power to make laws about the borrowing of money by the Commonwealth. Clearly the states wouldn't be making any laws about the Commonwealth borrowing money. So by its very nature, the power to make laws about the Commonwealth borrowing money must be a law-making power that is exclusive to the Commonwealth Parliament. Similarly, let's turn to section 51, subsection 19, that's XIX in Roman numerals, and you can see that this confers on the Commonwealth Parliament the power to make laws about naturalisation, that means who can become an Australian citizen, and aliens, which is a way of referring to foreigners. So this section gives the Commonwealth Parliament the power to make laws about Australian citizenship and foreigners. Now again, clearly this is a power that is only intended to be exercised by the Commonwealth Parliament. You can't have the different state parliaments having different laws about who can come into Australia, because Australia is the one country. So again, this is an example of a law-making power that by its nature is exclusive to the Commonwealth Parliament. And to give you one final example, let's turn to section 5132, which is XXXII in Roman numerals, and you can see that this refers to the power of the Commonwealth Parliament to make laws about the control of railways that are used to transport or for transport for naval and military purposes of the Commonwealth. In other words, it's the use of railways by the Commonwealth for defence purposes. And again, you can see from reading that clearly that power is one that can only be exercised by the Commonwealth Parliament, because the state parliaments have no business and no cause to make laws about the use by the Commonwealth of railways for military purposes. That then brings us to the final type of exclusive power, which are lawmaking powers that the Constitution prohibits the state parliaments from exercising. Now, you have to be a little careful with these, because when we are identifying this type of exclusive power, we need to find firstly a section of the Constitution which gives the Commonwealth Parliament the power to make laws about these matters, and then we need to find a section of the Constitution that says, oh, and by the way, the state parliaments must not, that is, the state parliaments are prohibited from exercising that lawmaking power. So I've given you 3 examples on the slides. Let's turn to the first of these. If we look at section 51, Roman 3, that's III, you can see that this is a section under which the Commonwealth Parliament has the power to make laws about bounties. Now, bounty is just an old-fashioned way of referring to subsidies, which means that these are amounts which are paid by a government to someone who produces goods. So to encourage them to produce goods, the government will pay them money. That's what a bounty is, and we can see that section 51.3 gives the Commonwealth Parliament the power to make laws about bounties. Now what we have to do to see if this is an exclusive power is find a section that says that the state parliaments cannot make laws about bounties or subsidies. And in fact, we'll find that prohibition is contained in section 90, which in the first paragraph says that the power to make laws about the granting of bounties on the production or export of goods, that is the power to make laws about subsidies, is exclusive to the Commonwealth Parliament, which means that the state parliaments are prohibited from exercising that lawmaking power. Let's turn to another example, which relates to the coining of money. If you look at section 51.12 in Roman numerals, that is XII, you can see that under this section, the Commonwealth Parliament has the power to make laws about currency, coinage, and legal tender. That is, it can make laws about money. In other words, the fact that we have a $5 note, a $10 note, and so on, that is the result of the Commonwealth Parliament exercising its power to make laws that say we have a $5, a $10 note, etc. So that's where the Commonwealth Parliament gets the power to make laws about money, and then we now have to find a section that says, by the way, the state parliaments cannot exercise that lawmaking power, and in this case we find that in section 115. Section 115 says that a state shall not coin money. In other words, states are not allowed to manufacture or to mint money, and as a result, states' parliaments are not allowed to make laws about the coining of money. So you can see here that this is an example of a lawmaking power, the power to make laws about coining money, or that is one that the Constitution prohibits the state parliaments from exercising. A final example is in relation to defence. If you turn back to section 51 and go to section 51 subsection 6, which is VI, you will see that the Commonwealth Parliament has the power to make laws about the naval and military defence of the Commonwealth and the states. So it can make laws about defence of Australia. And then if we turn to section 114 of the Constitution, you can see that this section says that a state shall not, without the consent of the Commonwealth Parliament, maintain naval or military forces. In other words, states can't keep their own armies, their own navies, and it follows from that that state parliaments can't make a law relating to their defence. So again, this is an example of a lawmaking power, the power to make laws about defence, that the Constitution prohibits the state parliaments from exercising, but authorises the Commonwealth Parliament to exercise, so is an exclusive power of the Commonwealth Parliament. Now you remember that I said that there are two categories of specific powers. The first was exclusive powers, and the second is concurrent powers. Concurrent powers simply refers to lawmaking powers that can be exercised by both the Commonwealth Parliament and the state parliaments. And all of these specific powers, that is, all of the powers which are expressly given to the Commonwealth Parliament by the Constitution, all of those powers that are not exclusive powers are concurrent powers. What this means is that if you look through section 51, then most of those powers, except for the ones we've covered that are exclusive, those powers can also be exercised by the state parliaments. So, for example, if we look at section 51.21, XXI marriage, the power to make laws about marriage, that is a power that's given to the Commonwealth Parliament, but nothing in the Constitution suggests or says that the state parliaments can't also make laws about marriage. And so this is an example of a concurrent power. That is, both the Commonwealth Parliament and the state parliaments can make laws about marriage. Of course, this leads to a difficult problem, because if the Commonwealth Parliament can make laws about a particular subject, and the state parliament can also make laws about that subject, then what happens if the laws conflict or clash with one another? How do we know which law we have to obey? Because the state law might say we have to do something, and the Commonwealth law might prohibit us from doing that something. So we're going to be in trouble. We can only comply with either the Commonwealth law or the state law, not with both. And that leads us on to a very, very important section of the Constitution, which is section 109. Now, this is the only section that the curriculum says you must be able to basically repeat off by heart. So let's look at what section 109 says, firstly, as it's set out in the Constitution. It says that when a law of a state is inconsistent with a law of the Commonwealth, the latter, which means the last one that was mentioned, that is the Commonwealth law, shall prevail, and the former, which means the first one that was mentioned, that is the state law, shall, to the extent of the inconsistency, be invalid. So when a law of a state is inconsistent with the law of the Commonwealth prevails, and the law of the state is invalid to the extent of that inconsistency. Now, that's a fair bit of jargon to remember, so let's put that into plain English. The better way, and this is what I want you to remember word for word, is to express section 109 as follows. It says, if a state law is inconsistent with a Commonwealth law, then the Commonwealth law will override, that's another word for prevail, the Commonwealth law will override the state law to the extent of that inconsistency. Section 109 is a really, really important provision, and that's because it is the section that tells us what to do if there is a conflict between a Commonwealth law and a state law. Now, obviously, Section 109 is only relevant to the concurrent lawmaking powers. That's because if we have an exclusive lawmaking power, then only the Commonwealth is able to exercise that lawmaking power. The states simply can't exercise that lawmaking power, so no conflict can arise. Similarly, if we're looking at the residual powers, then these are powers that only the state parliaments can exercise. The Commonwealth Parliament cannot exercise a residual lawmaking power. So again, there's no possibility of any conflict between a Commonwealth law and a state law where that law is made in the exercise of the residual powers. The only type of power where there could be a conflict between the Commonwealth law and a state law is where the law is made pursuant to the concurrent lawmaking powers, because these are lawmaking powers that can be exercised by both the Commonwealth Parliament and the state parliaments. So that's the importance of Section 109. Now, a few other important features to note about 109. Firstly, it only operates where there is an inconsistency between a state law and a Commonwealth law. It could well be that there's a state law about marriage and a Commonwealth law about marriage. And if they don't conflict with one another, that is, if there's no inconsistency between them, then you have to obey both laws, and both are valid. Both are perfectly proper and valid laws. So for Section 109 to operate, we first of all have to find that there's an inconsistency between a Commonwealth law and a state law. The second thing to note about Section 109 is that if we do find this inconsistency, then the state law is overridden. Okay, so the state law becomes invalid, but only to the extent of that inconsistency. It's quite possible that in a Commonwealth Act, which might have, say, 100 sections, and we've got a State Act with 100 sections, that there's only one section of the State Act that conflicts with a section of the Commonwealth Act. And in that case, it's only that one section of the State Act or law that is invalid. The other 99 sections are perfectly valid and continue to operate. The third thing to note about Section 109 is that
the state law will only become invalid to the extent of the inconsistency
where a court has declared that Section 109 operates to make that part of the state law invalid. What that means is that until someone brings a case before a court, typically the High Court, arguing that Section 109 causes part of a state law to be invalid, until that case is brought and until the High Court declares that there is some inconsistency and therefore the state law is invalid to a certain extent, then until that's the case, the state law continues on in force. And you have to obey both the state law and the Commonwealth law, which could be a problem if they're inconsistent. The final point to note about Section 109 is that it only applies to a clash between the state laws and the Commonwealth laws, not to a clash between laws of the territories, that is the ACT and the Northern Territory, and the Commonwealth law. So this only applies to an inconsistency between Commonwealth and state laws.
Now, I've set all of that out in a handout entitled Very Important Notes on Section 109.
And you'll see that the second page of that note refers to a case which is called McBain against the state of Victoria. And this is a very good example of how Section 109 can operate. In that case, we had a Victorian Act called the Infertility Treatment Act, and Section 8 of that Act said that the only women who could receive in vitro fertilisation, that is IVF treatment to help them have children, were women who were married or who were in a de facto relationship. In other words, women who were single could not be given IVF treatment in Victoria, and it was an offence to give them IVF treatment. The problem was that there was also a Commonwealth Act called the Sex Discrimination Act, and a section of that Act, Section 22, provided that it was an offence to discriminate between people when providing with services on the basis of their marital status. Putting that in clearer English, what that meant was that if you were providing the service of in vitro fertilization, that is, you're a doctor who was performing this procedure to help women have babies, then it is an offence to discriminate between married women and single women, that is, to discriminate on the basis of their marital status. So Dr. McBain, who was a doctor who provided IVF services in Victoria, found himself in a very difficult position. The State Act prohibited him from providing IVF services to single women, but the Commonwealth Act said that if he refused to provide IVF services to single women, then he would be guilty of an offence. So he could only comply with either the Commonwealth Act or the State Act, not both. So Dr. McBain took his case, in this case, to the Federal Court. It didn't go all the way to the High Court, but this case was taken to the Federal Court, and he asked the Federal Court to make a declaration that Section 109 of the Constitution applied, so as to strike out that part of the State Act that was inconsistent with the Commonwealth Act. In other words, he was saying that the bit of the State Act which said that IVF services could not be provided to single women, he was saying that that was inconsistent with the Commonwealth Act, and that therefore the State Act should be invalid to the extent of that inconsistency. And the Federal Court agreed with him. They said there was a clear inconsistency between the two acts, and that under Section 109 it is the Commonwealth law that prevails. Now in that case, it was only Section 8 of the Victorian Act which said that IVF services cannot be provided to single women. It was only that section which was inconsistent with the Commonwealth law, and therefore it was only that section which was struck out or overturned as invalid. The rest of the State Act, which consisted of hundreds of sections, those sections continued on in operation because they were not inconsistent with the Commonwealth law. All right, so that gives you an overview of the division of powers. Please make sure that you learn each of the definitions of the types of powers and learn at least one example of each type of power. And when we're talking about the exclusive powers, that means that because there are 3 categories of exclusive powers, you need to learn one example for each of those categories.
You must also learn what Section 109 says, be able to explain that Section 109 only operates where the relevant state and Commonwealth laws are covered by the concurrent lawmaking powers, and be able to explain the 4 points about Section 109 that we have just discussed.
Okay, I hope that has been helpful. Thanks very much.